Hi, my name is Joshua McKerley. This is for my public communications class at Lonestar online. This is my audience. If you could all stand up and wave to the camera, I would appreciate it. And my camera person, thank you very much. Appreciate you guys coming out. I am going to give a speech on informing you about the Second Amendment. This is an informative speech. I'm not taking a stance, and I'm not trying to persuade any of you about the Second Amendment or how you should feel about it. Just here to inform you. The Second Amendment is in the Bill of Rights. It's the very second thing that our founding fathers thought that they should add. What it states is that a well-regulated militia to secure an independent state, every citizen should have and be able to bear arms. It should not be infringed upon. What this basically means is that the national government doesn't have any control over laws pertaining to gun rights. In a Supreme Court decision in 1875, it was decided that gun laws should be regulated down to the states, and that they should have that power. Basically a check on the national government. The Second Amendment came out of retaliation to the British. Basically what was going on was that the colonies were becoming more and more independent, and British didn't like that. They were their colonies, they wanted to control them, and they were getting a little too uppity. And so what they did was they sent soldiers to occupy the colonies. When they did that, they realized that these colonists were armed, and they didn't like that. They figured that they might use these arms and try to kill their soldiers, which is precisely what happened. So the British government made a law that militias were unlawful and that citizens should not have the right to bear arms. So the second thing that the new Congress thought that they would put into their new constitution for this new government to check tyranny was to add the Second Amendment. Every citizen should have the right to bear arms, and militias are absolutely lawful as long as they're well regulated. The Constitution is ambiguous. It's that way for a reason. The Founding Fathers knew that as time passed, new things would come along, new ways of thinking would come along, and they wanted to be able to adapt. If you have hard and fast rules, they can't change, and people can interpret them only one way. Founding Fathers, in all their wisdom, decided that they would make these laws and these amendments ambiguous so that over time they could be adapted to. So, that being said, it's very clear in the Second Amendment that the national government has no right to abridge any kind of rights to the states or the citizens regarding guns. However, it does say a well-regulated militia. So it's a lot of controversy as to what does that mean. Well, the Supreme Court decided in 1875 in the U.S. versus Cruikshank that that was the precedent that said the national government has no control over gun laws. After that, it was decided that each state should be able to regulate their guns. Problem is, each state feels very differently. Texas has open carry in 2016. Obviously, very open with the gun laws, not very strict at all. Whereas California, with sovereignty over their own gun laws, has many stringent gun laws, background checks, long waiting periods, concealed carry, long periods for concealed carry to make sure you can actually get one. So it varies very much state to state, and it's due to a lot of controversy. So what people will look for are correlations between gun violence and gun laws. It's only natural. The problem with that is that there is no definitive proof for whether or not gun laws reduce or enrage gun violence. There are reputable sources on both sides of the table. The Washington Post, they did a study and saw that there was no correlation between stringent gun laws and reduced violence. Barack Obama believes that there are. After the Oregon shooting, he addressed the press, was quoted as saying that the state, we know, common sense, that the states with the strictest gun laws have the least amount of gun violence. Whether or not that's true is up for debate because terms are ambiguous. So what it boils down to is each of us as citizens have to decide whether or not we think gun violence is due to the availability to have guns. Some people will argue that criminals will always have guns, no matter if they're illegal or if they're not. And then some people will always argue that if there are more stringent gun laws, people will have less access to guns and gun violence will go down. Again, no definitive proof either way. We must make our own judgment calls and decide whether or not we believe as an individual, whether or not gun laws are a good thing or if they infringe upon our rights. In conclusion, I want to say that you should always be objective in your research. Research on your own. Find out what you believe as an individual and then support that cause. The key here is to be objective. So, according to the Constitution, you have the right to own any kind of gun that you want at any time, unregulated. Also, you don't. And you do. So, it's ambiguous. So my visual aid here, I had to improvise. You're not allowed to have firearms, but I planned on using a gun. So pretend that this framing gun, this tool, is a gun. It's my visual aid. That concludes my speech for now. I would like to ask the crowd if they have any questions for me. Anybody? What about my camera woman? My camera woman is the legal expert and the lawyer. If you could come up with a good question between now and the time you walk in front of the camera.
I'm not going to walk in front of the camera because I've already made my appearance.
Fair enough.
But if the Supreme Court has said that the states have the right to regulate their own gun laws, can the federal government then come in and say that the state laws are incorrect or unconstitutional and restrict what the states have granted?
They absolutely can. But any decision like that would have to go through the Supreme Court. The Supreme Court has already set a precedence against the national government in U.S. versus Cruikshank, where they basically said that the only point to the Second Amendment was to check the power of the national government when it came to gun laws. So they could, technically, but in case the Supreme Court has changed their mind and is willing to go against a precedent, they would have a long, hard fight ahead of them. So I would say that that's basically ineffective. Does that answer your question?
Yes.
Excellent. Does anyone else have any questions? Okay. Well, if you're against gun laws, I would recommend that you go get a picket sign, paint on it, make it out to say whatever nasty, mean things you want. You go and you write your congressman, and then you march in front of his door, like so, with the picket sign. And if you don't, if you think the gun laws are unconstitutional, I would not suggest that you do the same thing with a gun. So, in conclusion, thank you all for coming. Thank you for listening to my speech, and I really hope that I make an A.